Good morning, Your Honors. May it please the Court. My name is Thomas Sines, and I represent the Mendoza plaintiffs' appellees in this rather unusual appeal. The appeal before you is unusual in at least two critical respects. First, the state is at pains to recharacterize what is before the Court as a renewed motion to intervene rather than what it is, which is a motion for reconsideration of a properly denied and with sufficient time having passed a decision on intervention that had become the law of the case. And secondly, while the state invokes the 10th Amendment and talks about its sovereign right to establish education policy, it is decidedly inattentive to two other sovereign decisions by the state of Arizona. First, the decision by the state to delegate, through statute by the legislature, decisions over curricular development to school districts, including, in this case, the Tucson Unified School District. And secondly, the established process under state constitutional law, as well as specifically under Arizona Revised Statute 15-112, to determine the proper statutory construction of that new law potentially restricting ethnic studies courses. Now, these two unusual elements of the appeal have critical relation to the issues before the Court. First, with respect to whether this is a motion for reconsideration or a quote-unquote renewed motion to intervene, in fact, it has to be seen as a motion to reconsider. The state had moved to intervene, the decision was against it, it failed to appeal. It allowed the time to appeal to lapse before it came back before the district court and before it made any movements to come before the Court of Appeals. That then converted that decision to law of the case. It then had to ask for reconsideration by the district court. So the question before this court is simply whether the district court abused its discretion in applying Local Rule 7.2G, which would allow it to reconsider only on a showing of manifest error, and the district court concluded that there was no manifest injustice, or the showing of new facts, significant new facts, affecting the decision of the court. And here the district court also concluded that while there were new circumstances, specifically it identified the development of the unitary status plan, and the state, in fact, had brought before the court its assertion that a change of facts of significance was a change in the composition of the Tucson Unified School District Board of Education, and in fact the district court properly concluded that those would not change its decision on intervention. To be clear, Your Honors, the interest being asserted below in the district court by the state was not about the 14th Amendment, was not about preventing any violation of the 14th Amendment by the district court, but was in fact solely about that state law, Arizona Revised Statute 15-112. The very beginning of their initial motion to intervene states that they seek to intervene in this action on a limited basis as a matter of right to ensure that the special master's proposed curricular revisions for in-depth ethnic studies courses in the unitary status plan do not violate state law. Nothing in that sentence says anything about protecting against potential violations of the 14th Amendment in adopting a remedy for a proven violation by the district court. With respect to that interest in enforcing Section 15-112, in fact, the state's interest would not be impaired by this matter for two critical reasons that I've mentioned previously. First, the state has made the decision, a decision equally worthy of respect under the 10th Amendment, to delegate its authority to develop curriculum to school districts. It does that in Arizona Revised Statute 15-341, cited by the school district in this appeal. It does that and could withdraw that authority, but has not taken any steps other than what may have been done through 15-112 to withdraw that authority from any school district, much less the Tucson Unified School District. Therefore, its interest asserted here in enforcing that state law could not be impaired because it could simply decide to remove the discretion that it has granted and is not required constitutionally or otherwise to grant to school districts to develop curriculum. Second, and equally important, there is an established process to determine what is the authoritative interpretation of that statute 15-112. Specifically, it's already been invoked against Tucson Unified School District prior to the development of this unitary status plan. There is an opportunity, once the superintendent of public instruction informs any school district that he believes that it is violating that statute through one of its courses. In the case of Tucson, it was with the Mexican American Studies courses, to go to an administrative law judge and contest that. Beyond that, if the school district or the state disagree The conclusion by the administrative law judge, it then goes to the state court system, an appeal, as you would see in many other administrative matters around the country. It is then up to the state courts to determine what is the appropriate interpretation of 15-112 and how does it apply to the specific curriculum developed here in Tucson or anywhere else. That process for authoritatively constructing 15-112 is at least as worthy of respect as any interest asserted in developing education policy.
You mean while the federal court, the district court is developing those curricula and those programs, the remedies go into state court and ask the state court through the ALJ to declare the plan that the federal court is developing contrary to Arizona law?
That is theoretically what could occur, Your Honor. I doubt that it would occur. I believe that the asserted interpretation of that statute by the state, which appears to be that any ethnic studies course whatsoever violates the law, I think that's an overreading of the statute. I don't think it would prevail through that state court process, but that is the process to determine if the state's currently asserted reading is accurate or not, rather than going into federal court and having a federal court in the first instance attempt to interpret whether there is a violation of Arizona law, and then secondarily the critical question, does federal law, the mandates of the 14th Amendment, override that state law? But in the first instance, the state law should be interpreted.
How much of that is being litigated presently in this court in a separate case?
The question of the constitutionality of that statute is being adjudicated separately. But the question of how broadly it should be interpreted, even if constitutional, is a separate question not being litigated in that other action that would more appropriately be determined through the state processes that the state of Arizona, in its sovereign authority, has established for interpreting state law.
So play this out for me. Let's assume that the state pursues the remedies that you've identified and is successful in reaching a state court decision favoring its interpretation. Then what?
At that point, and only at that point, and once again, Your Honor, I don't think we'll get there. I think the state is overreading the statute. But if we do get to that point, then of course, we as the plaintiffs, if we still want to see that curriculum as part of the remedy, we would then have to introduce the state into litigation in federal court to resolve the issue of whether the 14th Amendment overrides that now authoritative interpretation of the state statute. But again, I don't think we get there, and the proper way to get there is to follow the state's established process for authoritatively construing its own law.
Right, but wouldn't the appropriate remedy at that juncture, if the state pursues its state remedies and successful, is to allow the state to intervene in this action?
Well, I think,
as
Your Honor,
opposed to initiating a new action?
What is more likely to happen is that the plaintiffs would probably seek to file an amended complaint to name them as a defendant if we still wish to have the curricular remedy as a part of the broad set of remedies in this case. Plaintiffs might well conclude we're no longer going to pursue that as a part of the remedies, no need to bring the state in, but I presume that's how it would occur.
It could fall out of the unitary status plan. There's about 3 ifs between here and there, but this could be severed off of the plan in the unitary status plan, couldn't it? And if not, then to Judge Thomas's point, there would be some mechanism, actually several opportunities for the state to intervene, wouldn't it?
Yes, down the line that is correct. If this remained a part of the remedy and there was an authoritative construction of the state law that indicated a clear conflict with what was going on in this case, we would have to resolve that conflict by somehow bringing the state into the litigation.
Right. Well, what the state wants, state wants a place at the table now. So whatever other remedies it may want to pursue, it may pursue. But we do have a state.
The problem with the state's intervention at this point is it would unduly delay the further progress of this now 40-year-old case, because they are taking a position, we believe an extreme position, that any and all ethnic studies curriculum violates the state law. We don't think that's an appropriate reading of the state law, but this is not the appropriate venue to decide that. The district court is not the appropriate venue to decide that. So, Your Honors, I do want to leave the time for the United States to address the issues. So with that, we urge you to affirm the district court's decision to deny the motion for reconsideration of intervention.
You want to give the United States 29 seconds?
Well, I believe, Your Honor, that they had their independent 5 minutes, and I want to make sure they have that, believing in their sovereign authority as well. Thank you.
Thank you.
Good morning. Holly Thomas for the United States.
don't have any note of what we did as far as allocating time. You're given an independent 5 minutes?
Yes. Yes, sure.
Out of the 10 or just in life?
Out of the 10.
All right.
Thank you.
Well, we'll give you the 5 minutes minus the 27 seconds. Okay.
Thank you, Your Honor.
Go ahead.
As counsel for Mendoza plaintiff stated, district court here did not abuse its discretion in denying the second motion for reconsideration of the motion for intervention, which is all that's before this court today. Arizona does not have a significantly protectable interest in this suit, but even if it did, that interest is not impaired by denial of intervention here. Arizona expressed an interest in ensuring that the ethnic studies curricula and the unitary status plan did not violate state law. That interest is both remote and it's speculative, and therefore does not meet the requirements for intervention. The MAS program, the Mexican American Studies program that Arizona repeatedly talks about in its pleadings in the district court, was canceled by TUSD. It has not been resurrected. The school district has not made any move to resurrect it, and indeed the district court has made clear that that program will not be reinstated.
Well, not the existing program, but isn't it fair to say, counsel, that there was a representation by the special master that some sort of culturally relevant program will be, that's the part of the plan, isn't it?
That's correct. There was representation by the special master that the culturally relevant curriculum and the multicultural curriculum would be part of the plan, but it's purely speculative that those courses will violate Arizona's
So what happens if they do adopt something like that? Then what does the state do?
There's a separate administrative process that the state can avail itself of to communicate with TUSD about any concerns it may have regarding the content of any curriculum. The content of the curriculum is actually not specified in the unitary status plan.
Right.
What's specified is just the development of those courses. And the fact that Arizona, in fact, was able to address its concerns regarding the Mexican American Studies program through this administrative process demonstrates, in fact, why intervention in this suit is not necessary, or why intervention at the present time is not necessary.
Well, isn't your argument, that's just to my point, isn't your argument that intervention isn't necessary now or wasn't necessary at the time? So in other words, that the court got it right, but that it's not so hard to foresee that there could come a time if an ethics studies program is adopted or some sort of culturally relevant program is adopted that the state finds objectionable. It's not your position the state wouldn't have a stake at that
Absolutely.
juncture, is it?
No, that's not our position. If the time comes when if the state feels that any culturally relevant curricula violated state laws, it's free to move to intervene again in the future. We have no position at this time about whether that would be appropriate or not. The question here is only whether the court abused its discretion in denying that second motion for reconsideration and finding that the changed circumstances cited by the state did not make intervention appropriate.
Is your position then that the state's argument is premature?
It was premature, as the district court held, and I think the district court didn't abuse its discretion in so holding. There, again, was no content to the curricula specified in that unitary status plan. So as the district court held, intervention would have been to essentially have an argument litigating the merits of the MAS program, which really isn't at issue here in this case. So yes, Your Honor. Again,
Is it now at a stage where there is a plan now that provides for the curriculum, or is it still being developed?
There is, and the curriculum has been developed at the high school level. The unitary status plan called for the curriculum to be rolled out slowly, first in high schools, then middle schools, then elementary schools. So that process is still ongoing, and Arizona still has every opportunity to be involved in that process through its state administrative procedures at this point.
But those procedures could conflict with what the district court order is, true?
They may or they may not. It's speculative whether.
Right, but I mean, let's say that the state takes you up on the invitation, contests it through state court. I assume that you would probably intervene and say, no, you can't do that because there's a federal court order.